You're listening to the Subrogation Support Network, a podcast from Mathieson, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. It's your host, Ashton Kirsch, joining you today for the Subrogation Support Network podcast. We have a fantastic subject today. We're going to talk about retaining counsel, when, how, where, tips and tricks on hiring attorneys. And so this doesn't seem totally self-serving. I've invited Patty Rodzinski with Secura Insurance, one of the Subro goddesses out there. She is amazing, and she has some great insights today for us. Patty, how are you doing?
I'm doing pretty good and glad to be here, Ashton.
Did you like that, Subro goddess?
Yeah, that's pretty amazing. Yes, thank you for that.
Well, so today I'm hoping we can kind of go back and forth, Patty, with things you see, tips, tricks on retaining attorneys. We can talk about some of the things that adjusters, claims handlers should be looking out for. When to retain counsel, how to retain counsel, and so forth. So I guess to begin, let's ask a simple question. Why is retention of counsel and good counsel so important to insurance companies?
Well, really, it's about the strategizing, the confidentiality, the creation of an action plan and the timeline, and then really the big thing, the recognition of potential avenues of recovery. As your representatives at carriers bring experience to the table, so do the attorneys that you retain. They share their experiences. They share anything that they can bring to the table to say, you know what, let's try this. It worked for me once. And I think you and I have done that, Ashton.
Absolutely. And, it's always a pleasure to work with your team over at Secura, some very experienced subrogation handlers. And we've been working together for years. So I think that's a big part of it, too, is, we'll go into some of the, the hard facts, right? Be it geographical or subject matter based. But also, I think it's important to have counsel and have attorneys that you can just pick up the phone and talk to, right? And that they,
Absolutely.
And attorneys are, we're well known for knowing how to research and know how to maybe argue. But communication isn't always our strong suit. So it's a big factor. The soft skills, right?
Absolutely.
So let's start about this first, right? Before we go into who you should look for, how you should look for attorneys, let's discuss a little bit about the procedures on when and where to retain counsel. I think one big thing that, we see is that some insurance companies, they kind of fear referral to attorneys, right? Obviously, you're going to have to pay us a contingency fee, pay us an hourly rate, whatever it could be. So it's kind of it's about finding the sweet spot, and it differs, right? I know you, Patty, have experience with both work comp and property claims, right?
Correct.
So in the work comp context, when do you decide to bring in counsel? Do you have a strategy or kind of a plan behind doing so?
Well, many times if an injured employee retains their own counsel, we have to have confidence in that attorney. And if we don't, that is a red flag to just get our own subrogation attorney that's going to represent our interests. So that's one of the things that we look for is the experience and our confidence in the attorney that's representing the case for that injured worker. So I know you've gotten involved in some of those cases where we're like, you know what, we would rather just have you involved, be at those mediations and be a seat at the table for Secura. And that seems to work well for us.
Yeah, and in the work comp context, I know that a lot of our clients, we do trainings and we inform them of kind of the necessity of intervening in a number of states. About half of the states, if suits filed, we strongly urge, very strongly, it's more of a must for intervention because plaintiffs' attorneys, even if they say, hey, we'll quote unquote protect your lien, that doesn't mean very much, right? Even when you have
sure doesn't, no.
Right in writing from them, frankly, their duty is to their client, right? Their duty isn't to the work comp carrier. Their job is to make sure you, work comp carrier, get as little as possible. It's not to get you your money back. It's to pay you as little as possible and then hope that there's no hearing after the fact when they offer some ridiculous number. And in many states, they can gerrymander settlements. They can apply claims to loss of consortium. Some states, pain and suffering that's not recoverable. And plenty of other times, if you're not actively involved, they're just telling you stuff. They're saying, hey, this is a garbage case. We're resolving it this. You should take this. If not, we're going to try it. Even, not to just drone on and on, but states like California. We just had a client, Patty, last week send me a case, and the case was in California, and they asked me to take a look at it and say, is there anything we can do about this? Plaintiff's attorney had the case. They settled it. Now the SOL is run. What rights do we have? And sadly, given the facts here, I tell them, you have no rights. You had to take legal action. You had to intervene in that lawsuit because in California, plaintiff's attorney can truly just settle at any time. And, there's various states like that where if we don't take legal action, you can just be out of luck. So that's not saying you always need to bring counsel in, but I always say, anytime suit's filed, be very strategic and have a plan in place for when it is we need to bring in attorneys.
Correct. You like to be involved and you like to know what's going on with the case. And sometimes they kind of forget to tell you that there's a mediation, or they forget to tell you of some important court dates. So that's why it's really important to have someone that is going to represent you and your interests and be involved and be informed of those upcoming important dates.
Yeah, and to go to some different context here, obviously that's work comp. On the auto side, a lot of times, you see carriers that they sit there and they say, well, why would we pay the attorney? Let's just keep trying the demand. Let's keep trying. And then we'll call counsel right before the SOL runs. Now, the hard part there is, first off, I've run the numbers, right? We've looked at the data and the metrics. After 2 or 3 demand letters, the marginal return is almost nothing, right? If they're not paying you on that 3rd demand letter, they're not just going to change their mind 8 months into the claim and say, oh, well, you sent us 6 of these pieces of paper. Now it's time to pay. Right. Instead, we don't want to wait. So on auto claims, my recommendations to adjusters are basically build a protocol, build a procedure in-house to say, what is it? Is many of my clients are, it's 2 demand letters, 3 months, or a denial that can't be overcome. At that point in time, there's no reason to work the case for another 2 years. 1, it's wasting your adjuster's time. 2, evidence deteriorates. And I mean, we just did an episode of this on investigations and claim investigations. And if you get me the case 2 years later, right, 5 days before the SOL, most of the witnesses aren't going to remember anything. The evidence is no longer there, and we just can't act as efficiently or effectively. So in the auto context, that's one reason. Get counsel involved if you can't get it resolved and the case is viable. And when I say viable, that doesn't necessarily mean that it even needs to be litigated, right? Attorneys can step in and assist. That demand letter has a lot of weight. So always keep that in mind, strategic use of attorneys. You agree with that, Penty?
We have a saying, Ashton, that subrogation claim specifically never gets better with age. So I completely agree with that. If you've been denied, why wouldn't you move it on? Why things still are fresh and that memories are still fresh, so that if you do go to litigation, you can really build a good case.
So another area where we get a lot of, we see a lot of referrals is product liability cases, homeowners claims. So no, Patty, you previously were handling quite a few of those over the years. So you have some good experience here. Now, one thing that we often see is products cases, they don't just get worse over time. They oftentimes are just done if you don't take action right away. There's a lot of steps that need to be taken, preserving evidence, making sure that we set the right scene examinations, lab examinations. If we file 2 days before the SOL, a lot of times we can't identify the right parties. So we get that case 2 days before the SOL. We tell the client, hey, we're going to do the best we can, but we have just the manufacturer, the company that it was branded as. But this dehumidifier, we don't know if there's any other entities, any component part manufacturers, any retailers, distributors. And sometimes you're just out of luck, right? Plus, oftentimes the evidence is just gone, so the case is just done for. But that's why in products cases, a lot of times our clients, and we see more and more often these days, they're getting us those cases right away, right? They know that there's a fire in their mind, for 2 reasons. Reason 1, you get the expertise. The attorney can pick their experts. They can pick the best experts for the case and litigation, referring you back to my last podcast episode released this week on expert retention. But the idea is we get involved early. You know that it's going to get done right. And secondly, just from a dollar and cents cost basis on a complex products case, it's really seldom that you send a demand and they just pay you, right? On a several $100,000 or even $1 million, multi-million-dollar products case, it's really, really seldom that they're just going to pay you on your demand letter. So you're going to have to retain counsel anyway. Might as well make me work for it, right? Make the attorney work for it on these cases, make them earn their contingency fee. And one way you can do that is by getting them products cases as early as possible. Did you see that when you were handling those cases, Patty?
Right. Generally, our saying is they're not going to cut us a check, right? They're going to defend their product as they should. And they have, a whole table full of attorneys that are going to defend it until, death. So that is generally one of those cases that we're going to get early involvement of counsel when we have a clear product liability case.
Agreed. And then the final matter that I just think is, we'd be remiss in not touching on is claims against government entities and municipalities. Every single week, I get a case from a client and I review it. It's slam dunk liability against whatever government entity, city of Tuscaloosa. And we get it and we say, beautiful case. But guess what? You didn't notice it up, right? There's a 180-day notice requirement. You didn't give notice. Your claim's barred. The government's, they have sovereign immunity. They're only liable for those situations where they want to make themselves liable for, basically. So in the end, if you don't notice it right, if you don't file suit within a requisite period of time. For example, I have a case just this morning, I was working on one where City of New York is a possible defendant. The other party is a contractor. It's a misdig claim. And we decided, because we can't rule out City of New York, we have to file suit. The SOLs, it's based on, it's a 1 year SOL pretty much, it's not actually what it is, but for all intents and purposes, we're filing about 1 year from the date of loss. And if we didn't do that, if we just waited on the basic property damage SOL, we'd be barred from that claim. And there's a possibility that that could impact the claim against the contractor too, depending on the involvement between contractor and municipality. So I guess in the end, one other place where I just advise all of my clients, just bring in counsel, is when there's a municipality on the other side. Because also practically speaking, Patty, how often are government entities just paying your demand and paying your claim?
Right. Same thing. You're going to have a very heavy defense. And on the carrier side, a big thing for us is the identification that it is a government or municipality claim. If you have a different department handling those claims than the subrogation department, because we need to see those files in order to refer those files. So that's just one of those things where you need to bring that awareness to the entire claims department so that those get referred in a timely manner.
Absolutely. I know all carriers do it differently, right? Some carriers have their designated subrogation panel. Others, the management decides who to use. There's one attorney that does it all. Other companies, the adjuster selects any attorney out of the yellow book that they want to. It's the first yellow book reference I've had for a while. I don't think do they even make those anymore?
They do not, I don't think, Ashton. I think those are gone.
To get off subject, I'm almost certain that if I showed my daughter a phone book, she'd ask, what the heck is this thing?
Yes, I agree.
All right, back on topic. So now we've discussed just the idea of not fearing referral. That's step one. Now, step two, you know that you need an attorney. You need counsel. What recommendations do you give your team on when, where, how to retain that subrogation attorney?
Well, I'm very appreciative of Secura because they give us a lot of leeway. As you mentioned, some carriers, their upper management is involved in every decision. I'm not a micromanager. I have a very experienced team that they can make those decisions and I can just support them or provide guidance if needed. We have a vetted list of attorneys and even experts available at their fingertips. They know, and if there's not going to be an easy resolution, it's better to get an attorney involved right away. We have those job aids as to retaining counsel, but every case is different. My team members have recovered large sums of money on their own, and they've recovered large sums of money with an attorney. I'm basically fortunate to have this experienced team, but basically they look at a file and they just know. And they know that it's probably best to get someone involved from the ground level to assist with that claim. Teaching this and how to recognize that to our new members is a challenge we're facing now because you just kind of know.
Absolutely. And the first piece of advice that I have is, remembering that you need to put your plaintiff's hat on, right? Subrogation work is plaintiff's work. I'm not running around the street chasing ambulances often, but
sometimes.
I leave everything open, right? But it really is. It's about remembering. When we hire, and my position is, and sure, this sounds self-serving because this is what I do, but I've learned that some of the best attorneys for handling subrogation work are those that have that, be it plaintiff's experience or have had that ability to gain that experience and learn that plaintiff's work is different. Defense work is, it's more procedural, right? It's procedural driven. There's step one, step two, step three. You're defending a case. Plaintiff's work, subrogation work, requires a lot more than that. It requires you to put on that plaintiff's hat to build a narrative, right? You're about building a story around your case to find a way to recover, because every case isn't a rear end collision, right? A lot of these cases, a slip and fall on ice, that's really tough in Wisconsin, but we've recovered on plenty of those. We've recovered together on those, Patty. And that's the big thing. It's about finding, in my mind, if I'm giving advice to clients, right? Find attorneys who can get creative, think outside the box, and build that case and argue that case from the plaintiff side, right? Do you agree with that?
I do. I mean, when we think about how it's important to think like a plaintiff's attorney, I say, let's be creative in our theories and also be creative with how we're going to recover. You need to be basically ambitious and assertive, similar to how a plaintiff attorney would be aggressive for his client. So those are things that we look for in an attorney who are representing us on those types of claims to make sure that we get the best dollar that we can.
So let's go to more on how you vet these attorneys. So let's say you're handling a case and you're trying to select an attorney in, I don't know, Arkansas, right? Select whatever state you want. What are you looking at? How are you making that decision?
We're looking for those common items that most people would look at, the trial experience, years in practice, client base, their success, their failures. All those things are important. But a really important element is, does their culture match Secura's? If not, it's probably not going to work out. I mean, we really need to be comfortable. And as Ashton mentioned previously, and I think Ashton can attest, and I can attest for him, you want someone that's going to answer the phone, someone that's going to be there when you need support or you need to be able to discuss that claim quickly. And also, handle that case that you've talked about and set an action plan, and it doesn't get farmed out to somewhere else. So that's some of those things that we're looking for. And if it's a good mix, then we're, happy. But if it's not, then we'll need to part ways because, like I mentioned, the culture is a huge thing for us. It needs to be similar to what we have here at Secura, which is really all about, making sure that we're doing the best for Secura, but also making sure that we're being assertive and doing the best for Secura's insured.
Well, one thing I didn't even think about going into this today, but I just thought about the idea of communications a bit further. And I want to touch on the idea of just status reporting, responding to clients' emails, and just that attorney being there for the client. I can tell you that I'd say 9 out of 10 clients that I bring into the firm, new insurance companies, self-insureds, they know our firm, right? We have all the charts and resources. But they don't come to us because, hey, my current counsel, the attorneys we use now, they're terrible attorneys, or they don't know how to litigate. Frankly, a lot of them come to us because the statement is, I've tried to reach my attorney for 2 months and they're just not responding. I'm sending email after email and it's crickets, right? So for my team, I train all of our attorneys, and I know a lot of other firms like us are kind of really implementing strategies like this to make sure that it's client focused, right? That we provide those updates, because what I've learned over time is, one, that's way more important to insurance carriers and claims people than elsewhere, because one, that adjuster needs to update the supervisor, who then may need to update the manager. And there's multiple stakeholders and parties looking at that files that they need to know that the file continues to move, right? And it doesn't help when an attorney, you send an email. We have a rule, attorney gets an email from a client, they have to respond day of, no later than 24 hours from that time of that email, right? Or else it's big trouble. What are your thoughts on just communications and kind of those soft skills for attorney? Is it as important as kind of I make it out to be, or is it
certainly is? I can speak for my team, and they will let me know when they are getting frustrated with trying to reach an attorney or being able to have a conversation regarding the case, getting into voicemails continuously, not getting return calls. It's very frustrating, and it's definitely a point that would be taken to no longer use that particular attorney, or in some cases, if it seems to be a trend within that firm. It's very important for us to be able to update upper management when they ask about a case, and to be able to have a current status report in the notes, even if it's just verbal, as to what's going on with the claim so that it's not going stale or it hasn't gotten lost in the weeds in case another department asks about this case if it's a larger loss, or the insured or the agent ask about that case. And it's just the last note is referred to attorney. We have nothing to provide. So I can't stress enough the importance of phone calls, returning them, providing just periodic emails and updates so that we are aware of what's going on, that the case is not fallen off into an unknown pond of water that is never going to be touched again, and that someone is actively working the case.
Right. And that's something where, so I just spoke at NASP on a topic like about 2 years ago on a similar issue as to, client communication, so far, the ethical duties for attorneys and working with carriers. And, that was the biggest gripe that everyone had. It's, hey, we have this amazing attorney, great results in litigation, power litigator, great CV. We just can't reach it, right? What do we do? And, I think it's endemic. I think it's part of maybe the culture in a way. And it's a culture that I'm trying to change for law firms. And
I appreciate that.
It doesn't always come easy, but all right. I'm glad you confirmed that, because that's been kind of at the forefront of my efforts over the last few years. Thank you for confirming the importance there. That's good.
Absolutely.
I'm of the perspective that I communicate sometimes to the level of annoyance. So, Patty, you can call me at any time. That's always the approach, is always being there for the clients.
Absolutely. And I appreciate that.
Relatedly, is it important to you for your attorneys to kind of be there to answer questions should it come up on other issues, right? On cases maybe they're not handling, or, maybe, to be able to there to discuss a possible referral. How important is that for you?
It's really important. I as I mentioned, I have a very experienced team with many of them working over 25 years together. However, of course, we have new people that are going to be taking our places, and they are learning and they have questions. And sometimes a senior rep or myself are not available. And I've encouraged them, work with the attorneys that we have vetted that are available to answer those questions. So I certainly don't want them to be frustrated trying to reach an attorney to answer a question or to talk them through a claim and they don't get back to them, or they get into a voicemail and they're just not able to answer that question when I've encouraged them to do that. That's frustrating for both of us. So I appreciate the availability for even to answer questions when it's not a case you're particular handling, but just providing guidance to my team. And you probably hear more from some than others, but it is appreciated. And I think that's an important aspect for a firm to offer that to their clients.
I totally agree. So now on to a topic that's a little more, I'm going to say uncomfortable. I don't really get uncomfortable. So I'm just going to toss out there. That's the idea of the contingency fee, the hourly fee, the fee arrangements. I know that this is huge in the industry, especially on like the defense side, where there's at every single claims conference, there's, attorney retention things, and everyone's talking about how fees are getting inflated. Though you look at it and you realize, well, attorneys' fees are pretty much the same as they were 20 years ago. So when it comes to like the contingency fee, let's focus on that. How important is the exact contingency fee basis for that firm to you? Do you see things that vary between firms? And does that impact your decision on who to use for referrals?
I would say it's pretty standard as to whether the case is in suit or actually in litigation, that we mostly work with contingency arrangements. We have had situations where we have a larger work comp lien, and as we mentioned, sometimes you need to or you should intervene, but we know it's really going to be riding the coattails of the driving attorney for the injured employee, and we work out some sort of hourly fee. But basically, I pretty much see it across the board the same, and it does factor in. Obviously, if you have a huge claim and there's not a lot of work, maybe you can work on some sort of hybrid arrangement or work on hourly and some contingency, things like that. But I would say it's been pretty consistent, at least in my world.
Okay. Because there's always a fear to a race for the bottom. And, for example, I said there's this firm that does almost exclusively bankruptcy. And then they recently said, well, we're going to handle subrogation claims at, I don't know, it's 15%, something crazy in litigation.
Really?
Well, that's, leading us to our next subject, which would be subject matter expertise. In my mind, I feel like if I'm an insurance adjuster, I'm going to be asking who has the experience on the specific subject matter. In your mind, how important is that when you're vetting attorneys? Are you looking beyond just I'm a subrogation attorney? into, I'm a subject, I'm a subject matter specialist in product claims, or be it work comp liens in Wisconsin. When you look at that, how into the dirt or like into the nitty gritty do you get with those things?
Pretty nitty gritty. I mean, as I mentioned, this would be a situation where one of my senior reps would probably provide guidance to someone that is just learning. And that's where they pull out their previous claims, right? I had a claim with this person and it really went well. They really knew a lot about it, or we both learned on that claim a lot about, battery fires, things like that. So it is huge. And there are, areas where we have, it isn't yellow pages, Ashton, it's online, but where we have our vetted attorneys and we can indicate, this claim number and this type of loss to help guide them. But there's also the training that they provided, the presentations that maybe we've attended that gives us an inclination that they're going to have a better understanding on this particular type of loss, this type of fire than maybe another attorney. But that is really the trial and error kind of thing. Sometimes you get burned on that, but it is really important to make sure that you are matching up the attorney with the appropriate case. There's some attorneys that can just roll with anything, but there are others that will maybe excel or do a little bit better on something that they've actually gone to litigation with or have done a lot of depots and are very familiar with the topic and this type of situation that we have for a subrogation claim.
Do I have good notes in that system? Does it say good
You
things
do
about me,
have
Patty?
you do have pretty good notes, Ashton.
Okay, awesome. So related to the subject matter expertise, quite often we'll have new clients come in and they'll be asking us, various questions about, hey, what's your recovery rate? What's this or that? And you can tell right away that they're using a debt collector for their subro work. And,
Okay.
I oftentimes, and this has been kind of a big sticking point in the industry and something that I discuss all the time. And it's, well, Ashton, what if you're not going to handle our uninsured auto cases, our $3,000 auto claim against a deadbeat driver, why would we just send you the good stuff? And, if for a long time, it was a hard question to answer. It's like, well, okay. Then you dig deeper into it and you run data, you look at the metrics and you realize that, if anyone takes anything away from it, it's this. Every insurance company who handles, let's say, auto claims that has uninsured work, you need a good debt collection firm. You need a solid debt collector. But that company is not going to be the same company that you should be using, in my opinion, on a products liability case, right? Or even on an insured auto case.
Absolutely. Absolutely.
Right. Yeah, subrogation firms that litigate like MWL or any of the other firms that you work with, Patty, and debt collectors are structured totally different. Like here's some inside baseball, right? Subrogation firm like us, our attorneys touch every file every week, right? We give status reports every 30 days, unless a client asks for further out. We are moving those cases and the attorney is on the file. Debt collectors, appropriately so, they're structured differently to handle quantity rather than necessarily quality. They're handling it with the requisite qualities they should for handling, 1,000, 2,000 claims for that one attorney. But they're relying on claims handlers, right? It's very procedure based. It's not about building those narratives and thinking like a plaintiff. It's about, recovering dollars. So, it's not to say that, subrogation attorneys good, debt collectors bad. Absolutely not. Both are equally important. But I think that's a huge thing that I try to convey to the industry is that you're not going to want to use that same person that's collecting on the $3,000 uninsured case as you are on the $500,000 dehumidifier case. You agree with that?
I absolutely agree with that. They are two different areas, and they're really, you would not want to give a product liability claim to someone that is handling 1,000 claims and basically using callers and things, and there's just not going to be that creative thinking, that one-on-one conversations regarding theories of liability and resolution. There is a whole different mindset because it's just, collection firm versus looking at this individual case and doing the best you can for your clients. So there is definitely a place for both. And we use both, but you're right. It does not make sense. There is no such thing as one-stop shopping. You really need to make sure that your claim that you have and what's involved with it matches up with the attorney that you want to work with and not just broad-based collection that just takes everything they got and starts calling on them.
Right. And so Gary Wickard and I recently presented, well, we do a webinar quite often called Top 10 Subrogation Mistakes. And we actually did a podcast maybe 5, 6 episodes ago on that. And one of the mistake is, grading yourself an A for D work. And it's the idea that it's really hard to assess how successful you are in recovering subrogation dollars because it's not comparing apples to apples always. A lot of times, if you're working with, this firm, that firm, every case is so unique. Every kind of case is different that it's really hard to grade your success. So I always encourage all clients, look and see anything you could be doing better, right? Review internally, look at the data and metrics and view every case specifically because, numbers don't lie, I know, but looking at things just across the board on recovery basis can sometimes be a misnomer, but that's just one piece of advice. Now, one thing I do think you have some really probably unique insight on is that retention of work comp counsel, right? And you hear from a lot of insurance carriers. I know that you guys do this differently, but a lot of insurance carriers, they say, well, we just use our work comp defense attorneys for handling the subrogation claim. Now, Patty, what do you think about that? What are the cons or what are the pros associated with work comp defense counsel handling the subrogation lien?
We have found, and I agree, I mean, that is something that is brought up. Hey, they know the case and, they can just handle your lien. They use that lien more as leverage or a tool. And there's just really no grit to get into actually recovering the lien. I won't say we have never used them, but I can say that we have seen better results when we use a subrogation attorney. Their mindset is different. They are really representing getting that money back. And it's not about, let's just get this resolved. Let's get a global settlement. They are in it for the subrogation department, and that's what we want. And really, there's such great networking in the subrogation world that sometimes there is some ins and outs that a work comp subrogation attorney would know in a particular state that the defense attorney would not know just because of, what conferences they go to, what presentations they're seeing, that they have a lot more insight as to what would fly and what wouldn't. So I think, great platforms such as NAS and continuing education presents that extra element so that you would want a subrogation attorney and, potentially get some money back rather than just waiving it or global settling it. It's really, we want to get some money back. We paid this in good faith and we want to see a recovery. And that's what I see when we hire our own subrogation attorney rather than using a defense attorney.
And to add to that, I mean, a huge part of what we do is it's the ability to assess the value of that third party claim. It's being able to, obviously, if we're pursuing it, sometimes we're hired to pursue the claim independently. So we are the plaintiff's attorney, right? Other times, frankly, sometimes we even find ways to do joint prosecution agreements where we represent claimant too in some states, largely on cases where maybe the case is relatively weak and it makes sense to combine. But on most of these cases, we're asserting a lien or we're just making sure we don't get settled around, right? But in those cases, one of the big variables is what is that third party case worth? And I think that's the hard part in my mind for a lot of work comp defense attorneys, because if you don't handle tort work, if you're not handling third-party litigation, plaintiffs, even liability defense side, you have a really hard time assessing what is this case likely to settle for? What's the true value of this case, which is a necessary element to determine what your lien should be valued at. And it's in the same way. Patty, don't hire me to give you an opinion on what the value of that case is on the work comp claim for a full and final settlement of the first-party claim. That's not my expertise. But in the same way, sure, I'm sure there's anomalies, right? There's plenty of work comp defense attorneys who also do, plaintiff's work or defense work on the liability side. But it's not the same, right? It's not judging and valuing a work comp applicant's case is not the same as judging and valuing a third party negligence case.
Correct. And we tend to get beat up pretty bad with a work comp defense attorney as to belittling our lien and the value of it. And like you said, you have a subrogation attorney that is going to look at it in a different light and help build it back up and the strengths of our case.
So, and that's always a big fear for a lot of my clients. We're getting these recommendations and we trust counsel, but one, either they may not know, work comp defense counsel may not know what that lien is truly going to be worth, what the likely recovery is. And or, the incentives aren't totally aligned. They look better when they can get that case resolved, even if they waive subro for something way less than what it's worth. A big thing to note is the future credit on work comp claims, that can be worth 5 times what the past medicals are, even more. And sometimes that's the big factor that it's really hard for those attorneys to really grasp because it is a complex thing. Future credits, future cushions, it gets to be really in the weeds, and you need to know how to value that case to get to that point. So actually, interestingly enough, I have a few clients recently who they've brought our firm in as national counsel, where we don't handle all of their liens in every single state, but we do have a role where every time a work comp defense attorney asks for a lien waiver, a subrogation waiver on a claim to X out the work comp case, they have to bring us in and we have a conversation. It's legitimately a 5-minute. I don't think one's ever gone more than 15 minutes. And we just discuss the case. They give me the facts. They say, all right, here's the net benefit we're getting from waiver to close out comp. What do you think the third party case is worth? Run it through the allocation formula. What do you think that plays out? Take a reduction for any liability issues that you see. And then we can kind of compare apples to apples at that point. We're able to say, okay, well, you're getting a $50,000 benefit to close out the comp claim. Likely recovery on the third party claim through allocation formula is $75,000. However, there's liability concerns. It's about a $25,000 difference. The risk there, you're getting guaranteed money today, maybe do it. But the hard part there is, I'd say in 80% of the conversations, work comp counsels recommend, when they are recommending waiver, they're recommending it. And we look at it's like, hold up, like it doesn't make sense. Take the risk because you can protect your future credit too. You're going to be able to take a holiday on benefits. You're going to get the same amount of money back. And pretty often they're getting more money back on the past meds, past indemnity, and they're also being able to take a significant holiday on futures. So, that's one piece of advice I have for all carriers. If you don't do it already, find Subro counsel you trust and just consult with them on it. Ask them those questions. It's, frankly, I don't charge my clients for it. I'm sure many other attorneys would be happy to take the 5 minutes on the phone with you to have those conversations because you can save a ton of money for the carrier in doing so.
Exactly. And it really comes down to the dollars, running those numbers. Does it make sense for the company, putting on the company hat saying, does it make sense to waive or do this, but also making sure you're getting insight and valuing it appropriately. So it really just boils down to what makes the most sense dollar to dollar.
Excellent. Well, Patty, any other things you look at when vetting attorneys? Anything else that you would add that you think is important to note when looking at retaining their Subro counsel?
Well, I think it is, as we mentioned, to make sure that it is someone that is going to be responsive, that is going to be able to talk to some of my newer members in a way that doesn't make them belittled, but also more of a partnership. We look for that kind of relationship where they, are basically responsive to any inquiries, bring in, a creative and theories for recoveries and, even roundtable claims with others in their department. And we bring them in and say, what are your thoughts on this? So we're looking more for a partnership with an excellent subrogation attorney that not only brings another set of eyes to the case, but brings their experience and their knowledge. Because, as you know, Ashton, we sometimes have to make a very quick and challenging decision on scenes and things like that. And that's where I want my team to learn through the counsel about scene preservation and about, other claims besides what we already know about, spread claims and spoliation, things like that. So we're really looking for a partnership at the end of the day.
And when you have that partnership, I feel like an important aspect of that is when you have trust in your attorney, just like trust in an expert or anybody else, there is a lot of room for having those conversations, right? I tell clients every once in a while, you know what? I know you want to send me this case, but you frankly include this quick statement of law, send a demand and see what happens before you send it to me. And, lo and behold, they recover the money and then they're incredibly thankful. And I see it as, that's when you have these future relationships in mind, when you're building relationships, when you're trying to build trust and long-term perspectives, it benefits everybody. And I think it plays really well. So I guess that's the other thing I'll add when looking for attorneys, find those people that you can trust, find attorneys that are looking at it from a long-term perspective with the company, because, claims are going to continue. There's never going to be a day where there's no more claims. So, there's plenty of work. So it's about building that relationship and making sure that we have, good partnerships together.
I would completely agree 100%. We're always going to be busy, Ashton, and there's always going to be room. So if you can, assist one of my newer members in doing a recovery on their own and build their confidence, the next bigger claim they're going to probably send your way. That's one of those things about building a relationship and building that trust.
Busy. I don't know. I don't know about busy, right? A couple kids driving around all over the place, handling
Chasing
claims,
ambulances.
I just saw one drive by a few minutes ago. I almost ended the podcast early to go run it down. Yeah, perfect. Well, either way, Patty, it's always a pleasure. Is there anything else you wanted to add before we kind of wrap up?
Nope, I don't. I think we got it all covered.
Beautiful. Well, I hope that the audience here found this interesting. Hopefully it wasn't taken as overly self-serving as a subrogation attorney telling you about why you should hire subrogation attorneys. But Patty, you really were able to add a ton to this. I think this is going to be an impactful episode for the audience. Audience, thank you all for joining me. Patty, always a pleasure. I'm sure you'll be on again in the future, and I guess we can give a plug. Patty and I are speaking together at the NASP conference coming up. We have a fantastic topic for the annual conference on what's the topic? Is it sparking new ideas on workers' comp?
Sparking new ideas in work comp subrogation in beautiful Phoenix, Arizona, and looking forward to speaking with you again, Ashton, because it's always such a good time.
It is a pleasure. Well, Patty, thank you so much. Thanks
Thank you.
for the plug. Anyway, audience, thank you so much. This is Ashton Kirsch wrapping up this episode of the Subrogation Support Network podcast. Until next time.